Students, because we are in a class that deals with drafting, it is important that we should talk a lot about what happens when you're drafting. I know that I'm repeating this subject because this is a point of emphasis. I want to emphasize that when you are drafting, you must have something called heading. So the face of your summons, where there is the mention of the seat of the court, that is called the heading, right? The importance of the heading of a pleading must never be underestimated. The drafting of the heading represents the initial phase in the drafting of pleadings and notices. You must take care that the heading indicates the four aspects, right? The first aspect will be indicating at which court is the matter being adjudicated, which means now when you say in the magistrate for the district of Qitshwayo held in Empangeni, now you are actually showing your opponent or the defendant as to which court will be adjudicating the matter. So that is important, right? The first one, just below the seat of the court on the right hand side of your page, you will then insert what is called the case number. Remember, a wrong case number can cause problems. You must always quote the correct case number. Once I've spoken about issuing summons. Summons are issued in court. The clerk of the court, Mr. Arens, is the one. Mr. Arens came to our class the other day. He is the only person who can issue summons. Issuing summons will be when you are given a case number, and those summons should be taken to the sheriff's office for the sheriff to deliver them, that is now serve them to the other side, your opponent. Then once that is done, he will then go and file something called the return of service. Okay, once you've got your case number, and you must, like I've said, always make sure that you write the correct case number, even if you are let's say you are the defendant and the plaintiff has said it's case number 2 or 27.8, then you can't say 27.9, because once you do that, it's going to go to a wrong file at the office of the clerk of the court or the registrar, depending whether this is a high court or this is the magistrate court. So you need to be very careful with your case number, because your matter can be lost, your response can be lost because you quoted a wrong case number, right? Also, you must indicate the parties to the matter, right? If it's a simple summons, there will only be one party. If you are, like I said, when you're applying to be admitted as an attorney, it's an ex parte application, or you're applying for a curator ad litem, that's also a simple summon. It's going to be one party. So if it's two parties, you will indicate that plaintiff is Mr. John and the defendant is Mr. Peter. So you need to put the name and surname of the plaintiff and the name and surname of the defendant, right? And also you must state as to what type of a document is this. In the 2 lines that I've shown you to draw, and I've told you when you draw a line, you take your laptop and because you are on now Word. When you are drafting someone's, you will be using Word. So you take your cursor to the U that has got a line underneath, that's for underlining. You highlight that, it changes color to dark, and then you then bring your cursor to where you want the line to be. You press your cursor, and at the same time you also press where it says tab. Where it says tab, and you press the area where you want the line to go. After having highlighted the U which has got a line underneath, that's for underlining, then you will press the tab continuously. You will see a line going, and then you write the subject underneath, you draw another line, but make sure there's a gap in between. I don't like people who draw the line just on top of the words and immediately just underneath of the word. That's not, there must be a gap in between. And also bring that name of the document to be at the center of that line. You must leave gaps on both sides so that it's in the center. It's not on the extreme right or extreme left. It must be at the center between the two lines with gaps both sides. And it's either you can say it's a notice of intention to defend, or you can say it's application for summary judgment, or you can just say it's plea, just write plea. That is now the type of document that you are drafting. It has got to be there. Right? As I've already indicated, the golden rule for drafting of pleading is that you must always important. I cannot overemphasize this. You must always consult extensively. You must know. You must know the facts of your action. It is very important, so that you don't tell your own story. You actually tell the story of your client. And also you must always use simple English. Do not come with bombastic words when you are drafting your summons or your particulars of claim, or you come with simple, straightforward English that everybody can understand, because people might protest because they say they don't understand. The most important thing is that for somebody to respond to your allegations, they must understand. And you must also set out the main points of the claim or defense if you are a defendant, and ensure that you set out all the facts necessary to support your claim or your defense. Everything that is there. Like I've said, you must also attach the agreement. Those are used to support your claim. And also, if you are a defendant, you will do the same. You will attach documents that will support your defense. For instance, you might attach a bank statement and highlight where you say a certain amount was deposited to the plaintiff's account. That's now we are trying to prove that what the plaintiff is saying is not so true, because you've got proof, right? When you but also remember, when you are dealing with a matter where you want to repossess where you want to repossess a house, you need to state in your combined summons, because I remember I said it will be combined summons where you are suing somebody who has failed to pay a bond or failed to pay a loan from the bank. Then you must also mention that section of the maybe credit, normally Section 11 of the Credit Agreement Act 75 of 1980. You need to say that action is in terms of the Credit Agreement Act 75 of 1980, for instance. Right. So now we come to the again. We must mention the procedure. I've told you the procedure that we start with the letter of demand, and then you do summons, and then after summons you will be doing what is called the particulars of claim, and the other party will file the plea. Right. In the plea you must indicate which allegations contained in the plaintiff's particulars of claim or declaration you admit, deny, confess, and avoid. You must indicate which facts are not admitted and to which extent they are not. You must clearly and concisely mention all material facts whereupon the defense is based. So you say my defense is based on, like I said, it's based on the fact that there is a bank statement that proves that my money was paid, right? And also, like I said, when we are dealing with paragraphs, you will say add paragraph 1 of the plaintiff's particulars and state the defendant admits the contents of this paragraph. And again, you say add paragraph 2 of the plaintiff's particulars, and then you say you must be in black, in bold letters, and also put the is it a hyphen, and put the hyphen, and then say defendant admits the contents of this paragraph, and then add paragraph 2 of the plaintiff's particulars of claim. Say the defendant denies the contents of the plaintiff's allegations. Or we can also say the defendant has no knowledge of the allegation contained in this paragraph, cannot admit orderly same, and puts the plaintiff to the proof thereof. That is now you want the plaintiff to do what? To prove his or her allegations, right? Or else you can say the defendant has no knowledge of the allegation contained therein and thus denies the same, right? Also, you must take care that you are acquainted with the substantive law applicable to the specific case when you draft a plea, as certain defenses must be pleaded specifically. E.g., like I said, if somebody has got no locus standi or has got no authority. Locus standi means you've got no authority. You can't claim on behalf of your brother. You must claim only that which belongs to you. You cannot claim for someone else, right? So you'll say the plaintiff has no title, right? And also you must also set out the material facts of your defense clearly and concisely. You must also include your prayer. Like I said, always include your prayer, because the court will say what is it that you want the court to do, right? And also, if you are a defense, you must include in your prayer that you are praying that the plaintiff's case must be dismissed with costs. Always remember the issue about costs, that for everything that is for every appearance in court, there must be cost. So if anybody says no, today we are not ready because the papers are not in order, or the counsel or advocate for the plaintiff is sick, then you must demand costs, because your client would have paid you to go to court. So you need to you need to demand costs as well. Right now, well, I think we need to talk about, I think that we've said a lot about everything. We need to talk about how to draft the how to draft the heads of arguments. Heads of arguments are very important. That when you have a matter, you've done your pleadings and you've done everything, you've inspected, but now you must have heads of argument. Whether it's an application or an action, it has to be accompanied by the heads of argument. And remember, you must file your heads of argument timelessly so that the presiding officer or presiding officer, sometimes you will find that you have three judges looking at your matter, so you have to draft the heads of argument and have them printed in maybe say 6 copies or 4 copies, depending on how many people are involved in that case. But each and every one must have a copy. So how do we now draft the heads of arguments? Right, when you're drafting arguments, you begin by identifying the issues. Some people start with introduction. You'll have a heading that says introduction. There you begin by identifying the issues, and the next one, and also you must number each paragraph. You must number each heading. You say introduction. Say introduction will be number 1, and then you come to number 2. We call them paragraphs. So say paragraph 1 is introduction. The paragraph 2, and it's where you give, maybe you say you give a background. Background will be where you give a summary of the material facts of this matter. Then maybe paragraph 3, it will be where you set out the proposition of law with reference to authority. Now you are starting your argument. You will say this matter might be argued in terms of a certain legislation, if you like, or a case law that will be used. You're actually stating the case law or legislation that will be used to support your arguments, right? And there also you must also apply the propositions to the facts. This is how you're going to go about it. And then the last one will be where you do now your conclusion, right? The conclusion will also include the relief of which each litigant, whether you are a plaintiff or the defendant, that you feel you are entitled to. Right. Another important thing is that your pleadings must be signed, and if the matter is in the High Court, it has to be signed by an advocate and no one else, or an attorney with the right of appearance in the High Court. And if your pleadings are not signed, then there's a problem. Also, the same thing, your heads of arguments must be signed as well. Right? So that is how the heads of arguments are done. And you can get in the pack that I gave you, there will be examples of heads of argument. Then you can look at that, and that is how it is done. So for now, let's stop there. If you've got any question, please feel free to consult me, because it is difficult to teach people when we are sitting in an office like that alone. You don't have anybody to engage with, because I am used to a way of teaching where I engage students and make sure that they understand. Otherwise, if I'm alone in an office like this at this time of the night, then it doesn't make sense to me. But I hope you've understood whatever I said. Thank you, student.